Supplementary cause list. Item number 1, announcement of judgment.
For the reasons on discussion matter, there is no merit in this repetition, so I am dismissed.
Any mention?
Your Lordship, I'm mentioning item number 3, Lordship. If this matter may come up after 2 weeks, Lordship.
Item number 3.
3.
Who is the other side?
I'm both the respondent. Lordship.
Nakma matter.
Yes, Lordship.
Yes.
No objection, Lordship.
When do you want it?
After 2 weeks, Lordship.
Just say 3. After 3 weeks on the request.
Obliged.
May I please, Your Lordship, I beg to mention item number 5.
Yes.
I'm
You are
appearing
appearing for?
I'm appearing for at 3 and 4.
State is also a party. Yes,
I'm both the petitioner, Lordship.
What is the matter of here?
This is
Appointment.
Department of Proceedings. Here the petitioner is not cooperating with the Department of Proceedings.
No, that is okay. Then what role private respondent is to play?
He is for
Municipal.
municipal.
municipal, not the private agent, municipal.
Municipal employee. It is with regard to municipal employee.
Yes,
Yes, Lordship.
I mean, the state does not have that. You are for the petitioner.
Yes, Lordship.
Yes.
I'm praying for 2 weeks time, Your Lordship.
Lordship.
Just say. The respondent, private respondent, what's going on?
Highly obliged, Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 8, Your Lordship.
Yes.
I pray that the matter may be listed after 2 weeks, Your Lordship.
You are appearing for?
Private respondents number 4 and 5, my lord.
This guy, GHDC is a party here.
Yes,
Appearing
yes.
on behalf of GHDC.
Okay, just say 2 weeks on the request. 2 weeks.
Yes, Your Lordship. Much obliged.
May I please, Your Lordship, I beg to mention item number 7.
Yes.
I'm praying for 2 weeks time, Your Lordship. I'm praying for 2 weeks time.
Why you are praying for time?
We need some more time.
Hmm?
We need some more time to go through the affidavit filed by the
In
state.
2019 matter, you need some more time to go through the affidavit. Yes.
Your Lordship, I have no objection.
Say 2 weeks.
Much
Yes.
obliged.
On the request of the petitioner.
Your Lordship, I beg to mention item number 13, Your Lordship.
Item number 13.
13.
The last item.
Your Lordship, kindly give us 2 weeks time, Your Lordship.
Yes. This is quashing application.
Yes, Your Lordship.
Yes, Mr. Guru.
I have no.
13, 2 weeks.
Oblige, Your Lordship.
Yes, no more.
Lordship, I beg to mention item number 10. Pray if the matter may come up after 1 week.
Yes, Mr. Jiru.
It's a part hurt matter, you know.
Part hard matter. Is it kept part hard?
Part hurt, yeah.
It is kept hard. It's kept part hard.
Hurt last on the 4th of December, Your Lordship.
And therefore, it is been kept. It has not been shown as part hard. Was it?
No, it's reflected in the order dated 4th December that it has
has
been,
been kept
both
part hard.
parties have been hurt.
But
But
that
then
is a
further.
normal cause of order. Whether has it been?
No, hurt at some length. That is the word, yes.
It's not been kept as part hard. Okay, 1 week after on the request of the petitioner.
Highly obliged.
Right, Your Lordship.
Main list, item number 1.
May it please your lordship, I'm appearing on behalf of the conducting counsel for the petitioner, Mr. JM. Thank you. Your lordship, we have received the application for recalling and setting aside the order 16/7/2018, wherein the respondent number 4 was being set in ex parte. So it is my humble prayer on behalf of Mr. JM. Thank you, that we may be allowed to file a response to this application
Now, who has filed the application?
from the respondent number 4.
Are they present? They are not present. Then,
Please,
if they
Your
are not
Lordship.
present, we will dismiss their petition also.
May please, Your Lordship. I'm
Yes.
appearing for the.
So you are not
Private
appearing.
respondent.
He is making a prayer without you being present.
Sorry, Lordship.
You want to file an objection?
If you want to file a response.
They have a right to file a
I have
response.
that liberty, Your Lordship.
Okay.
Your lordship, since the petitioner resides in East Garo Hills, it must take some time for him to travel all the way to Shillong.
Okay, we'll give you 3 weeks and then we'll see what happens. Okay. You are appearing for opposite party number
Number 1.
One, Your Lordship.
Number 1.
number 1. And who is for 2, 3, and 4?
I'm appearing on behalf of JJDC.
You also will file objection or
We haven't received any copies.
I'll supply them today, Your Lordship.
okay, Mr. Swain sir, Lana Council appear for the. This order will be passed in the miss case. Miss case number 51 of 2024. Is it there in the list? Is there? Yes. Just say. For just say hard. You reflect name of Mr. Nagpur as petitioner. That's so and so. Then 1 for his name and 2, 3, and 4 are none. Then you say Mr. So and so appearing for the appeal number 1. Praise for grant of some time for filing an objection against the petition. Prayer allows at least after 3 weeks.
Much obliged, your lordship.
Then petition also. List is met after 3 weeks. Yes.
Item number 2.
May it please your lordship.
Yes.
Lordship, this matter we are supposed to bring on record that certificate of petitioner number 1, your lordship.
So what is to be done?
Lordship,
If it is pending for getting a copy of the death certificate of.
yes,
Can you give us the date of death?
that we can ask.
Then we'll
your
record it and then just delete his name from the array of parties, isn't it?
Yes.
Otherwise, it's pending like that for only for that purpose.
Lordship, weeks time may be granted, your lordship.
You see the order sheet; it has become much more thicker than the writ petition. Okay, Mr. Day, there is no other option.
Yes, my lord. So let it be a last chance, my lord, because now this matter of that
If we say it
certificate.
is last chance, and if they fail to do it, then what would be the consequence? Then
Because,
Can
because,
we-
because the
can
matter is not proceeding, my lord. From
that is okay. But then
2023.
say supposing if it doesn't come, can we?
Because the petitioner itself, according to my understanding, is not interested. That is why they have not contacted them.
We're talking about the lawyer, not.
No, I'm not talking about a lawyer. I'm talking about a petitioner, my lord.
Otherwise they should have contacted my lord.
Just give one more time and then we'll see
Just
what
the
happens.
nutshell of the case is this, my lord. Whether they are the blood relation of the Nokma or not. If they are not the blood relation of the Nokma, they cannot come and challenge anyone's appointment.
Locus standi.
Yes, no locus standi. Moreover,
Because
my
he is
lord.
not praying for himself. He is not saying that you appoint me as this.
Yes. Here, his challenge is this. My daughter has been appointed. My daughter has been appointed as a Nokma. She is the only daughter. So the lineage will go to the daughter, my lord. How he can object?
That is all right, but then if you see that, say supposing, let us see if he has this. But see the prayer. He has not made any prayer to appoint him.
No, there's no dispute on that. But who will be? Someone has to be there as a Nokma.
Definitely.
And if my daughter will not become the Nokma,
So it's a proxy case.
appears so.
He is advancing cause of others.
My lord.
And just on the request of the Land Council of the petitioner, further one week's time is given, granted, to produce a copy of the death certificate of the petitioner number 1. Please take it.
Item number 4.
My lord, here, as per the last order, my lord, the state was directed to obtain certain instruction, my lord. I'm yet to receive the instruction. There is
This
a
was passed by, this had gone to, this was passed with the order was passed by the Chief Justice.
Yes, Your Lordship. Yes. There was a confusion as to the reservation, my lord. Percentage, whether it is 3% or 4% for the special category.
What is the subject matter of the case?
My lord?
What is the subject matter of the case?
My lord, the petitioner is, allegation is that, claim is that the percentage of reservation for a special category is 4%, not 3%. If it is 4%, then he will be entitled for appointment, my lord. My stand is, my lord, it is 3%. So on that point, my lord, state was supposed to file certain, bring some record, my lord. So I'm here to receive the instruction, my lord.
So you are asking for some more.
My lord.
You are objecting.
No, Your Lordship.
No. This subsequent notice,
My lord.
does not override the previous notice. Your notice was of 2006.
My-
2006.
yes,
That is in 2017.
My lord.
So that is where you need instruction.
My lord.
There is no reference of that previous notification in the 2017 notification.
No, my lord.
Normally it is done.
But in my affidavit, my lord, I have relied on the 2006 notification, my lord. So on the last hearing, the
this
petitioner came
affidavit
out.
was filed after 2017.
My lord. However, my lord, I'll seek instruction on that.
No, you will have to seek instruction. Just a minute. This court is trying to get the
Yes.
gist of the order. Why it has come before this bench again?
I do not know.
There is a change in the roster. But then doesn't say about this thing that anything about that you'll be filing anything, Mr. Gurung, this last order?
My lord,
does it speak of anything?
order dated 18/3/2024. The second paragraph, my lord.
18.3.
18/3.
Yes.
If I may read, my lord.
Yes, yes.
Second paragraph.
Yes.
Learned State Council drew the attention of the court to the notification
yes,
dated 38/10/2006 and
Yes,
some.
yes, it's there.
Yes, ma'am.
Well, Mr. R. Gurung. Learned G appearing for the state respondents. Praise for grant of further 2 weeks time,
My lord.
for seeking instruction as per order dated 18/3/2024. Yes. Stop. Prayer allowed. Dish after 2 weeks.
Item number 6.
May I please, Your Lordship?
Yes.
My lord, this matter pertains to the land acquisition for the purpose of setting up of the Balpakram National Park, my lord. My lord, there are two parts that I would like to.
My lord, my senior Mr. SN is the conducting counsel for the state. He is on his legs. I'm humbly praying that before my learned senior begins, this matter may be taken up at the end of the board.
We can start because it will take some time. By then, he might join.
If Mr. Shan is not there,
Yes,
it
my
will not be
lord.
possible
At
to
the end of
handle
the board, my lord. At the end of the board.
You will overpower him.
No, my lord. All right.
So what do you want? At the end of the board or?
At the end of the board, my lord.
At the end of the board.
Item number 9.
Please, Your Lordship. I'm supposed to file an affidavit to bring the charge sheet. This matter at the time when it was filed, it was FR. Now, reinvestigation. Now, charge sheet has already been filed. Now, charge sheet I just received 2 days ago. So I need some time to just study and file the affidavit. At least 2 weeks.
Yes. Mr. Matna, learned counsel, appearing for the petitioner. Praise for grant of for the time for bringing into records a copy of the charge sheet filed in Thurapi's case number 99 within bracket 7 2020. Prayer allowed. List after
2 weeks.
2 weeks.
Pleasure.
Item number 12.
What to do? My lord? My
Now,
friend
this is
has
the
not
end
yet
of the
come.
vote. Now, what to do?
If not taken today, then it will be after elections only.
And that is up to you, you to decide, Mr. Of course, it
Oh,
is
he has
put on
come,
90.
he has come.
Yes, Mr. Shen is here.
This is not the one. This is not the one. This is not the one. Don't touch all this. My lord, there are two important factor or the events, my lord, and which I would like to highlight, my lord. The first is what had happened before 2011, that is pre 2011.
Just if you give the
Yes.
fact of the case,
Yes.
you say until this court gets the fact, then
Yes, that's what I try to do, my lord. Yes, so the pre 2011, my lord, would narrate the facts of the case, and there is another event that happened post 2011, and 2011, my lord, and that would constitute my grievances and my prayers, which I am seeking remedy from my lord.
so it means the post 2011 part gives you a cause of action.
Course of action, my lord, and the pre 2011 runs out to the events, my lord. Events how the entire accusation took place, in what manner, and when we went to the High Court on the Guwahati High Court Shillong bench, my lord, what the order came up in this, my lord. One part ends there. So I will just.
There is a previous round of litigation.
Yes. So, my lord, what happened is that in the year 1985-86, my lord. 85-86, my lord.
Let's to such this thing.
Yes.
Old goes. Okay.
Yes, my lord. 85-86, my lord. The government, my lord, had acquired around 220 square kilometer of land, my lord, belonging to Akhings, my lord, of the Nokma land, my lord, of 10 Akhings, my lord. 10 Akhing land, it was acquired. And they were paid at the rate
You are
of
representing
rupees.
all the 10 Akhings?
Yes, my lord. We are an association, my lord. Yes. Association consisting of the 10 Akhings, my lord. 10 Nokmas, my lord. So, for 220 square kilometers, my lord, 10 Akhings were paid 3.63 crores, my lord. That would be, my lord, rupees 1.65 lakhs per square kilometer, my lord. That was the first phase. Of acquiring of 220 square kilometer. The second phase, my lord, of additional 76.25 square kilometer was acquired in the year 91-92, my lord. 91-92 by paying same amount, my lord. Same. And the third phase, my lord, additional land of 15.5 square kilometer was acquired in the year 1994, my lord.
All by different notifications, isn't it? Issued at different stage of.
Different stage, my lord. Different stage, my lord. Now, and the finally, my lord, the fourth phase was acquired in the year 1995, my lord, and that was 39.91 square kilometer.
What is the total stretch of land?
The total stretch of land that they have acquired is, my lord, 352 square kilometers, my lord.
It's a quite big, huge area.
Huge area,
So
my
it
lord.
means first part is on the one side of the thing, the last part is on the other side.
My lord, additional, they keep on, because in between some other Nokma's land were also there, so they was also acquired. So, my lord, now at that relevant point of time, my lord, the Nokmas, my lord. Why I'm saying this is because that is the contention.
So this
Yes.
land of petitioners are
Yes.
involved in all four phases of acquisition.
Yes, all four phases of the acquisitions, my lord. So now, my lord, these Nokmas were initially, my lord, asked to sign in some blank papers, my lord. And that was a contention raised before the Guwahati High Court also, that in, my lord. And that purportedly happened to be an agreement, my lord. In a blank paper, that purportedly to be an agreement, my lord.
It's not a blank agreement. Subsequently,
my lord, something must have written after that, my lord. So,
that
my lord,
done by the state.
By the state, my lord. So, my lord, and the contention in the year 2002, when we filed a writ petition before the Guwahati High Court, my lord, and the writ petition was numbered as 31315 of SH of 2002, my lord. In that, these are the contentions that we raised. Now, my lord, in the year 2002, when we filed the writ petition, there were already other writ petitions pending before the Guwahati High Court, my lord. Before
the same acquisition process.
Yes, my lord, by different Nokmas, my lord, who were not a part of my.
You are not representing all the Nokmas.
No, we are representing only the 10 Nokmas, my lord. There are also some other Nokmas, my lord.
So they are not part of your association.
They are not a part of my association, my lord. So as an individual Nokmas, my lord, they have already filed a writ petition pending before the Guwahati High Court, and the very relevant two petitions are there, my lord, which is very similar to my petition. Those are the civil rule number 152 SH.
These are all mentioned in your writ petition?
Yes, it is. My lord, I'm saying, my lord, I'm saying from.
No, it's okay. See,
Yeah, it is a part of the report.
Mentioned, this court will not know.
It is a part of the record. It is a part of the record. And my lord, and another civil writ petition is of 153 SH of 1997, my lord. So these two weapons. Then we file our writ petition, my lord. Essentially, these two writ petitions which were pending before us, and my writ petition representing 10 Nokmas, my lord, by an association, my lord, the contentions were all same. Now, my lord, these petitions happened to be disposed of by a common judgment, and the common judgment was of 22nd.
Heard together.
All matters were heard together, and it was disposed of by a common judgment, that is 22nd of February 2011, my lord. And my lord will find that is from page 17 onwards, my lord, of my writ petitions, my lord.
Yes.
It is. Now, my lord, in this petition, my lord, two directions were given, my lord. Now it will be relevant to refer to the page first, my lord. I will just show, my lord, page 17
of your writ petition.
Of my writ petition, my lord. Page 17, my lord.
Yes.
Paragraph 2, my lord has it. Paragraph 2.
Yes.
Paragraph 2. My lord, may I just read?
Yes.
In WPC number 315 SH of 2000, that is my petition by the association. The petitioner is an association of Nokmas of the Aking land situated in South Garo Hills, Meghalaya, and is registered under the Societies Registration Act of 1860 by the registration so and so, so and so. In the year 1985-86, the state government, for the purpose of setting of acquired, proposed to set Aking land of 7 phases. In the first phase, 10 Aking's lands were estimated area of 220 square kilometers were acquired at a cost of rupees so and so answer per square. Again, second phase, this is what I have just told my lord. So we can skip all these things. Then we can go down, my lord. This is what I have just narrated to my lords. And then we can just go to paragraph 6, my lord. Oh, the page 18. Page 18.
You are not saying from this thing, this is part is not this thing, that your contention that there is no proper land acquisition proceeding initiated.
Yes, my lord. I'm so grateful, my lord. Yes. So no proper, the last part after the king purpose, then it is the case of the petitioner. Except for this 114.85 square kilometer of land, no proper land acquisition proceedings were initiated apart from issuing notifications purportedly under section 4 and 6 of the Land Acquisition Act of so and so, and the unsuspecting illiterate Nokmas were made to sign on blank papers which were made out to be agreements. They were never informed of the rights to receive money under protest or their entitlement to higher compensation in the absence of adequate compensation. Moreover, according to the petitioner, in assessing the rate of compensation, the respondents totally ignored the rate fixed by Garo Hills Autonomous District Council and paid them rupees 1.65 lakhs per square kilometer, which worked out to be a mere 200 per biga. While determining the quantum of compensation, the value of standing trees, crops, mineral deposits, etc. were not taken into consideration. Solatium was also not paid, ignoring the provisions of the Act. Now, from the own pleadings of the petitioner, it becomes obvious that the landowners represented by it are aggrieved by the quantum of compensation awarded to them between 91-92 and 95-96. In my opinion, it is now too late in the day to challenge the award made some 7 to 15 years before. Moreover, if the petitioner is really aggrieved by the quantum of compensation so awarded, it had a remedy under section 18 of the Act for reference of by the collector to land, provided that it was filed within a period of limitation prescribed there. Having not done so, the writ petition insofar as 352 square kilometer is concerned is barred by non-exhaustion of an alternative remedy. So the rest doesn't concern us. Now this has plain res judicata to us. This has played. I'm just saying the negative.
So it means your case was rejected on the ground of limitation.
Limitation. Now, my lord, I will just show another order of the same order, my lord, directions. Now, my lord, will come to page 21, my lord. Page 21, paragraph 5, my lord. Page 21, paragraph 5. Now, this is the civil rule which I was talking about, which was filed before me.
Yes.
In civil rule, may I read, my lord? In civil rule number 152 SH of 1997, the 5 acres lands belonging to the 5 petitioners were also proposed to be acquired by the government of Meghalaya for extension of Balpakram National Park in the year 85-86. It is alleged by the petitioner that the forest officials, after initial measurement of the land, obtained their signatures on some blank papers which are made out to be agreements for parting with the respective lands for the consideration 1.5 lakhs per square kilometer, and the valuable lands were thereby expropriated by the payment of nominal sums in the name of compensation. The grievance of the petitioner is that the value of Nokma Aking land in 1979 was 1,000 per biga, and the total value of the land was taken over should have been 7,48,000 at this rate, but the forest department proposed to pay only 1.5 lakhs per square kilometer. It is also contended that the usual norms which have not been followed in the land acquisition proceedings were completely given a go by in this case. Be that as it may, the petitioner in paragraph 6 of the writ petition revealed that compensation at the rate of rupees 1.5 lakhs per square kilometers was calculated and paid to the Nokma, but in the same breath, they contend that the area of land acquired in 85-86 is now being questioned. In my opinion, the conclusion is inescapable from the averments of the petitioner that they have been awarded the compensation of the rate far below the rate fixed by the district council, and for a smaller land than actually acquired by the state respondents. If that be so, they ought to have approached a collector to refer the dispute raised by them under section 18 of the Land Acquisition Act for the decision of a land acquisition court. Having not exhausted the alternative remedy provided by the Act, this writ petition is not mandatory. The petitioners are, however, directed to file an application under section 18 of the Land Acquisition Act 1894 for referring the dispute to the Land Acquisition Court if permissible by law. The collector will examine as to whether such application will be time barred or not, and thereafter take a decision in accordance with law, accordingly dispose of. Now, another writ petitions, my lord, paragraph 6 is mentioned. Coming now to civil number 153 SH of 1997 and civil rule number 154 SH, the facts in this case are virtually similar to the foregoing civil rule. Therefore, if and when an application for reference under section 18 of the Act is filed before the petitioners jointly or severally, the same will be considered by collector along with the lines indicated above.
So in no case section 18 was,
yes,
application was filed.
My lord,
in all 3 cases,
yes,
That was the position.
That was
and
a-
it seems primarily
yes.
apart from the issue of limitation.
Yes.
This is the ground.
Yes.
For not
So-
attending the writ petition.
Yes. So now the same situation, the same similar case, the same amount of compensation, the accusation the same over the same adjoining lands, my lord. One or in the same stroke of the order bars me, but for the other there was a relief given, my lord. Now, my lord.
Even so far as Section 18 is concerned.
Yes, my lord.
That
Yes,
is not-
Section 18 is
it
concerned.
Section 18 is not dependent on court's order. You have a right. This is a statutory right.
Yes, my lord.
It is not
So-
created by the court's order.
Yes. So now, so my first, so this is the first part of pre 2011 ends here, my lord. The first part. Now the question, some question that comes to mind is, my lord, what happened to Civil 152 and 153 and 154? What happened to those, the orders that have been given to them? Whether they have, the petitioners file their applications under Section 18?
You tell us. You are putting a question, or you are to.
My lord, that is for the government, because we are not aware, my lord.
That is for you. See, you have come before. You cannot shift the burden to them.
My
But
lord.
you come with the contention and tell them to bring the proof.
My lord.
If you procure proof, then only you will have a cause of action. Otherwise, no cause of action.
My lord. My lord, now the thing is that, my lord, what I am saying is that now what happens to those accusations? Had they filed? If they have filed, and what was the result? Whether the amount, yes, whether the enhanced amount has been given, and if that's been given to them out of the same adjoining plot of land for the same purpose, location same, my lord, then that will amount to discriminatory and inequality, my lord. And who is to rectify this, my lord? So the thing is now, my lord, now yes.
Do you think you are arguing on the right track?
My lord, no, this
Now,
is, I'm only
sir,
asking the,
supposing-
yes,
Rates differ. You said 3 separate land acquisition proceeding.
yes,
3 separate award.
yes, yes.
Okay. Now, if rate varies, will it result in discrimination?
My lord, over if the subject
If you want to
matter,
bring it, see,
yes,
I do not know from the what at least till now what could reveal to the court. I don't think you have a remedy under 226.
my lord,
You do
my,
not have any case here.
my lord, my lord, that is post, my lord, yes. That's why
Rather your
yes,
petition is barred by res judicata.
yes, my lord. My lord, now that is why I was showing forth the best, the worst case scenario of my case, my lord, because that is the post,
It's the best
post.
case scenario.
That's
Why worst case
that's a pre, my lord, because now, my lord, the question that I ask myself is, my lord, when a judgment comes, my lord, against me, my lord, does that bars me from filing a representation to the government? Because keeping in mind,
Have you done it?
keeping in mind, my lord, yes, keeping in mind, my lord, when I have given my land for a public interest, my lord, for the public interest, my lord, when I've given my land for the public interest, and the authority who has taken the money or who has taken the land knows themselves that they have paid me below the market value, my lord, but just because I came to the court, but the court closed its doors saying that you are too late in a day. You are too late in a day. On technicalities, I was shunted out, but the grievances remained. The grievances remained, and that is the fact of the matter. So does that bars me also filing a representation? Now I'm coming to the post 2011, my lord. Thereafter, my lord, I have filed representations, my lord, still agitating because thinking in the public interest point of view, my lord, when I have given such a big land which belongs to my community, which belongs to my ancestral land, my lord.
Filed a Section 18 application after the disposal of that of the earlier writ petition, isn't it?
No, my lord, first of all, what I did was that Section 18 application per se, my lord, we have not filed, but there is a report, my lord. There is a report.
Report means?
Report, my lord, we have filed, rightly or wrongly, we have filed our representations, my lord, and from 23 onwards, page 23 onwards, my lord will see our representations. Rightly or wrongly, we have filed our representations to the chief minister, my lord, to the chief minister, to the government. We thought that, my lord, is a village people. We thought that is the head of the government. So the first representations that we filed after this was 5th April 2011, my lord. 5th April 2011. And in this, my lord, we have very clearly stated also, my lord, what has happened, my lord, and why we are still aggrieved by this. Then, my lord, comes the second representations comes 03 February 2012, my lord, and that is page 27, my lord. Here we have reiterated the same thing, my lord, saying that
It was written to whom? Second representation was addressed to?
To the chief minister, my lord. To the chief minister, my lord. And, my lord, then the third representations comes in September, my lord.
That is also to the chief minister.
To the chief minister, my lord. That is to the chief minister, my lord. And my lord, finally, my lord, few pages I'll just like to show, my lord. Then finally there was an inquiry under secondary legacy, my lord. This is little important, my lord, from the law department, and
inquiry by law
page
department
36
into the proceedings,
my lord. My lord, now page 36, this is important. After all my representations, my lord, this has come page 36, my lord. This is little important for me, my lord. Therefore, I will take my lord.
Just a minute.
Switch off this mobile.
You say page 36?
Page 36, my lord.
That is the response to all those representations. That is
all representations, my lord, and this is a letter of Deputy Commissioner, my lord. Deputy Commissioner of the South Garo Hills, my lord.
17th August.
Yes, my lord. 17 August 2012, my lord. Now, this is addressed to the Under Secretary to the Government of Meghalaya, Revenue and Disaster Management Department, Shillong. Subject: land acquisition in respect of BNP, means Balpakram National Park, and the matter relating to the representation of the President/Secretary of the Balpakram Aking Nokma Welfare Association. Reference. Sir, in response to your above letter directing me to take action according to the law in matter, I have the honor to state that I have made an in-depth examination as to whether a reference to civil code can be made at this stage. In this regard, I have gone through Civil Rule number 2016 of 1990, decided by the then Justice Dhiren Barua Guwahati, so and so, Supra. This is a case in which the government of Meghalaya had acquired 5,803 bighas of Aking land, paid rupees 100 and 200 per bigha to the landowners as compensation. The landowners had not accepted the award.
Yeah, come to the bottom point. Instead of reading this thing, come to the authority part.
So the finding is given at, my lord, page 39, my lord.
Yes.
Page 39. Giving my consideration thought to the entire matter, I find, what he says, the case of Balpakram acquisition are more than 27-28 years old. The illiterate people were paid only 1.50 lakh per square kilometer, which is abysmally low by any standards. Number 2, due to procedure prescribed in LA Act for acquisition of land was not followed, resulting in great economic loss to the rustic Nokmas. Number 3, the government of Meghalaya, wedded to the concept of tribal welfare, is perhaps duty bound to mete out economic justice to the aggrieved Nokmas, especially. Reference to civil code will not merely consume lot of time, but will also highly expensive for the state. In view of the above, I felt inclined to make a reassessment of the land acquired with reference to value of per biga and the land existing as per the district valuation at the relevant period which is enclosed. My action finds ample legal support in a division bench decision of our own Honorable High Court in Winkle-Starr's case reported in GLT. In the above premise, I place before the government who may perhaps be pleased to consider the above views absent. Now, he is the district.
So then what happened? What the government did?
Nothing.
So this is your cause of action.
This is my cause of
This is
action.
the entire case about.
This is the
Why
cause
your
of
deputy
action.
commissioner wants to give? Why you are not giving?
I'm not sure under what provision this has been done. Lords. How can they resort to something
that
of this
is
nature?
right. See,
And
definitely.
also the basis is the district council valuation, which Lordships are aware, district council does not have the power.
See, we are not going. See, this court in whatever way will not go into the rate.
Yes.
No question.
And
Now, only thing is to be decided whether this can give him a fresh cause of action.
in my humble submission, no. Not at all.
Come to Land Acquisition Act. This law itself will say, Section 11. Once a word attains finality, how it can be?
Only under Section 18.
Until and unless it has been referred under Section 18 and all, enhancement cannot be like this.
Precisely.
The law does not permit an authority to again make another award.
Exactly. Lords.
So there is no question of whether this is written rightly or wrongly. You see, this cannot create any right.
Correct.
In favor of
This is
the
not
petition, so
permissible.
far as the law is concerned. Now this will be for him how he places his case. It's like which
Lordship.
way. You see, it is a letter. We do not know how a deputy commissioner came to write it and what is the government reaction so far as the function of this deputy commissioner is concerned. That also we do not know which way you have taken this letter. What is the government response of government so far as this
Let's,
letter is concerned?
as far as the question of replying to it, we've not filed any reply. What we filed,
There
we
is no
challenge the
question of filing a
maintainability of the
reply.
entire petition.
It's
But then
appropriate,
which
they
is-
would
what is
file.
your comment so far as the functioning of the deputy commissioner is concerned?
Kindly see thereafter, there is a response here.
My lord, may I submit? Affidavit in opposition has not come till date, my lord. The best, my lord,
the reason is
affidavit
because-
opposition should come, my lord.
The reason is
Affidavit opposition
because
has
No,
not
no,
been filed.
it has not come, my lord.
with the information of the court, we did not file an affidavit on the merits of the case. We challenged the maintainability of the proceedings, my lord.
On the res
Kindly see
judicata.
the order sheet. It was in motion stage for a very long time, then in admission. They have
Anyway, it has been admitted. It has come up for final hearing.
it's come up for hearing.
So the best is let them file an affidavit in
No,
opposition,
we
then
don't
we
need
can
to.
go.
We don't need to. First, he must establish a couple of things. Lordships will recall from the last orders, they were required to comply with the particular order of this Honorable Court. Kindly have the order dated 7/9/22.
This court would not have entertained your petition, Mr. Yuvin.
My lord.
I know that has always been the
No
case.
way, a word. You see, which, what is the order dated?
Order dated 7/9/22. My lords, we have confronted them with several issues which affect the maintainability of the case, and they were required to answer this.
Yes.
Lordships have it. Order dated 7/9/22. This is when this matter was being heard. Mr. P. Ubin, learned counsel for the petitioner, on being queried by this court as to the status of the petitioner association, praised that he may be allowed 2 weeks' time to obtain necessary instructions. This is with regard to the status of the association as on the date of filing of the.
But then it was
case.
not that the instance of the same association earlier writ petition was entertained. At least it was rejected on the ground of limitation, but then it was not rejected on the ground of, you see, like locus standi.
Correct. I'm saying as on the date when this writ petition was filed, whether they were still registered. That was the question that was posed by the court itself. On 7/9/22, this was a question which was posed by the court. If Lordship will kindly have page 9 of their writ petition.
Just a minute.
So, my lord, I'll just formulate the issue. The queries that were put by the court.
Give me one.
My lord.
Page 9
First, can you have page 2
of their
of the writ petition?
of the writ.
Of the writ petition.
Yes.
Kindly see the cause title, my lord.
Yes.
Who's the petitioner? The description of the petitioner.
Yes.
Balpakram Aking Nokma's Social Welfare Association, represented by its attorney, Srimati Ruthila R. Marak. This is a similar question. Lordship may not recall. Lordship had posed the same question. Why is this association being represented by attorney? So this is on the dint of a power of attorney, which is at page 9 of the writ petition.
Yes.
So this is a power of attorney which is dated 11/5/2017. Now kindly see, it reads, "We Arbinstone Marak, son of so and so, is the president of Balpakram Aking Nokma Social Welfare Association, South Garo Hills, and Derison Momin, son of so and so, is the secretary, Balpakram Aking Nokma Social Welfare Association." Then kindly see the recital at page 10, the first paragraph of page 10.
Yes.
Whereas by virtue of the resolution passed in the minutes of the proceeding held on 12 June 2010 in an emergency meeting of the Balpakram Aking Nokma Social Welfare Association, headquartered Bagmara, South Garo Hills, in the residence of the secretary, Derison Momin, allowed Shri Arbinstone Marak, president, and Derison Momin, secretary. Therefore, the aforesaid president and secretary of the said association were pursuing the matter with the government for getting fair land compensation and or enhancements of the amounts paid for acquiring the aforesaid land, and they have already spent substantial amounts, but the matter has not been finalized by the government collector till date. We are finding it very difficult to continue with the matter anymore, because all the time we have to visit and stay at Shillong, for which we have incurred very substantial amounts while pursuing for getting fair land compensation, solatium interest, etc., and on enhancements from the government of Meghalaya. Whereas we have already filed different representations to the various authorities of the state for payment of fair compensation, solatium interest, etc. But now we are facing extreme problem to pursue further. Therefore, we have decided to constitute and appoint Srimati Ruthila R. Marak, daughter of so-and-so, resident of so-and-so, as our attorney to pursue the matter further with the state authorities in connection with the Balpakram National Park. Then kindly see the powers that were vested upon her. This is at page 11.
Yes.
Number 1. The attorney shall do whatever she considers necessary to pursue our matters pertaining to compensation and or enhancement, solatium interest, with the government collector, South Garo Hills, Meghalaya. The attorney is authorized to spend whatever amounts necessary while pursuing the matter further with the compensation and or enhancements, solatium interest, with the collector, government, South Garo Hills. The attorneys are authorized to institute suit, appeal, revision before the competent court, and to file representation before the appropriate authorities or the state for compensation and for enhancement, solatium interest, etc. The attorney are also authorized to engage any pleaders, other persons in our interest and on our behalf, for the purpose of pursuing compensation and or enhancement, solatium interest, etc. with the government, South Garo Hills, Meghalaya. That after the land compensation and or enhancement of the compensation, solatium interest, etc. is done, we agree to issue the checks. Kindly take note of this. We agreed to issue the checks duly signed by us to our attorney as their share before we withdraw the remaining amounts, as stated in our earlier individual deed of agreement dated 16 June 2012, that it is hereby agreed and made clear that this power of attorney shall not be revoked at any cost to avoid any losses and damages to the above named attorneys.
So it means power of
This
attorney has
created
been
a-
executed after one agreement was.
Yes, so there was valuable consideration involved. So this was something that played on the mind of the court, and therefore the court had queried and directed them to place this on record. Now, repeated orders were passed. In fact, lordships had posed this question to them. Kindly then see, in this context, the order dated 27/6/23, which I understand lordships had passed.
26.
27/6/23.
Something wrong with the order.
No, they were directed to place all of this on record, all these related documents. Because even lordships found this particular stipulation in the agreement, in the power of attorney, quite suspicious.
Order dated 27. 27/7/2023, you said.
27/6/23.
This order by Justice, thank you.
Lordship, I apologize. By Justice, thank you.
Yes.
On query by the court, petitioner undertakes to produce original certificate of registration and other related documents for adjudication. Now, I am certain my friend will not dispute that other related documents pertain to this particular reference here. This agreement dated 16th June 2012. So thereafter, time was given to them, and finally they filed an application. They filed an affidavit which I received on the 9th of October 23. This is filed on the 10th of October 23. Lordships have the affidavit filed by the petitioner. This is an additional affidavit.
What page you are referring to?
Of the affidavit, my lord,
by 12th June, affidavit will bring on record the resolution dated 12th June 2010.
Lordship, an affidavit to bring on record the resolution dated 12th June 2010
Yes.
and authorization dated 16/6/2012.
Authorization means? Was there
Authorization to this attorney. The
but
authorization
that is
to
the power of attorney which you have read
And
out.
in the power of attorney, Lordship will see stipulation number 5. Clause 5 refers to another individual deed of agreement.
Yes.
Dated 16th of June 2012.
But that is agreement and this is authorization.
Yes. So there are two. One is a resolution which was taken by the members of the executive members of the association. I am referring to annexure 4, which is a deed of agreement dated 16th of June 2012, which was referred to in the power of attorney.
Yes.
So Lordship will find that at page 11 of their affidavit, the last page.
Yes.
So just before I proceed, in clause 5 of that agreement of the power of attorney, there was a reference that they agree to pay the attorney the sum as indicated in the checks.
Yes.
And as stated in the earlier individual deed of agreement dated 16 June 2012. Now, this is the agreement of 16 June 2012.
That is what is mentioned in the paragraph 5. Sorry,
Yes.
clause 5.
Yes,
sir.
yes. So I'll just read this out. The deed of agreement executed on this the 16th day of June 2012 between Srimati Prostina M. Sangma,
Yes.
daughter of late Melton M. Marak, Aking of Nawarochang, Aking Land PO and PS Bagmara, as one part known as the first party, and Arbistone Marak, president of so-and-so Nokma Welfare, and Derison Momin, secretary of Balpakram Association, or on the other party known as the second party. This agreement relates to completely different people. The president and secretary are there, but Ruthila Marak, who's the attorney, as mentioned in the power of attorney, is not a party to this. Yes. This is a completely different deed of agreement, which is why there is no reference to those checks, those bankers' checks, which was referred to in clause 5. There is no reference of this here. I'll continue to read
So
this.
you want to say that the attorney holder is not the person, not a party here.
I'm not saying that, Malaj. I'm saying that in their power of attorney, there was a reference to some agreement of 16 June 2012,
Yes, yes.
pursuant to which Ruthila Marak had been specifically empowered to represent them before the courts. And there was a reference to some checks which were to be paid to her. This agreement is not an agreement with Ruthila Marak. So I'm sure there is an agreement. They do not want to produce it before the court. That is what I understand. Otherwise, there is no reason why Ruthila's agreement would not be produced before the court.
Then what relevance will have this agreement will have in this adjudication?
Because there is some sort of financial transaction between the attorney and the association, and which is what had come from the court as well. This is public money at the end of the day. These poor villagers, they've been made to believe that a huge amount of money would be procured from the government.
Make an order for NPR.
This was something which was being inquired by the court, which is why Lordships have passed successive orders directing them to produce these documents before the court.
But then these documents, supposing if you are supposed to, then where is that document? Then it means he is correct in his contention.
My lord, no.
This may be agreement executed
Yes.
on the same day.
Yes.
But then this is not an agreement which you have executed with the attorney holder. Where is that?
My lord, if I may clarify, Prostina M. Sangma is one of the Nokma out of the 10 Nokmas. She is one of the Nokma out of the 10 Nokmas. I have authorized our president and a general secretary to act on our behalf, to appoint attorney, to appoint agent. So for the best interest of for all of us, they have appointed an attorney in the name of Ruthira. So what is the harm in this, my lord? I've already given the power to my president and my general secretary, my lord. And rightly, my lord, if the government is so aware or so concerned that Ruthira Marak is going to take away all our money, fine, give us the money. Therefore, admit it. By way of their own revenue or the collector, they have admitted. They have paid it loss. Now the concern that they are showing here is that Ruthira Marak is going to take. My lord may restrain Ruthira Marak from obtaining. Give to our individual accounts, to the 10 Nokmas, calculate. If they are so concerned.
Well, again, just to clarify, this was not my concern. This is a concern which came from the court. My friend should be very fair with this. This stipulation in clause 5 was a concern that was raised by the court itself. That what is this transaction that you have with Ruthira Marak? We need to examine this because it's public money after all. If public money is being paid to you, what are you actually planning to do with it?
And petitioners are villagers, they are ignorant, uneducated. So they may be,
correct.
Simplicity may be
misled.
Lordship. They may be exploited by somebody.
Exploited.
There might be some form of exploitation here, which is why this concern was raised by the court itself.
Say, supposing now, do you want to say that there exists no such agreement which has been referred to in paragraph 5, clause 5 of the power of attorney?
My
do you
lord,
want to say that there is no such agreement?
My lord, there is one agreement which, my lord will recollect, my lord. I will not say anything which is not there. I have personally, my lord, had a meeting because, as I said, on the first occasions that this was drafted by, this is an, it was given to me, was drafted somebody, and I have not even talked to my clients, who are my clients. I'm not talking about the attorney. The villagers, my lord. We have made an arrangement, we have talked to them. And my lord, they are saying that there is an agreement, but that agreement is nowhere says that. But they are not able to keep, hardly, my lord, we got one agreement, which is this, which is of Prostinas, my lord. The rest of the agreement, it is not there, my lord. Therefore, we are not, therefore, as an example, but it is drafted in the same language. And they were also saying, my lord, but that is on record. I cannot say that, but just my information, my instruction, they're saying that there was no, this, the manner in which the attorney, the power of attorney drafted, it is not, they're not very much aware.
What is this agreement about? What is this annexure 5 is about? Page 11.
Page 11 of.
What the stipulation made there? That which Mr. Sen has referred just now. Annexure 4 to your last affidavit.
Yes, my lord.
So it means like it has no relevance so far as this present matter is concerned, writ petition is concerned.
My lord, this can be.
But then this power of attorney relates to this writ petition.
No. This is not a part of this agreement.
Correct. So this agreement forms part and parcel of the transaction between the principal and the attorney.
It's all right, but then this agreement refers to somebody else, not the attorney holder.
No, well, let's kindly see that after the land compensation and or enhancement of the compensation, solatium, interest, etc. is done, we agreed.
No,
that is the principle.
Right. That is all right. But
yes,
then
Lord.
If you see, the petitioner here is not Prostina, isn't it?
No, that's what Lordship has observed. Possibly there were multiple agreements that were made.
So that is what see.
So the actual agreement has not been placed before the court.
Just hold on, Mr. Shah. What this court is trying to is this. We are not at all concerned about where there exists some other agreements or not. Not at all we are interested to know it. We just want to know about the power of attorney and the stipulations made therein.
Lordship.
Now, as you refer to clause 5 of the power of attorney, it speaks about existence of an agreement between the attorney holder and the power giver.
Yes.
Executant of the power of attorney, isn't it?
Lordship.
Now, if at all any papers have been conferred by this court in relation to the power of attorney, that means that agreement would be agreement which has been referred in clause 5 of the power of attorney.
Yes,
that will be a relevant document.
That would be a relevant document.
So far as the petitioner and the power givers are concerned, isn't it?
Yes, yes.
This is that way irrelevant, isn't it?
The document which has been produced before the court is irrelevant.
This one which you have referred just now, that page 11, it has nothing to do with power of attorney.
It appears so because they're completely different.
This party, one of the parties here, or the first party there, is not the attorney holder.
Correct. It's not the attorney holder.
So we cannot relate it with the attorney.
Cannot.
So if
there is no
confine
nexus
ourselves
between
to
this and
clause
that.
5, as you say,
Lordship.
there must be another agreement.
Correct.
Maybe dated same day.
Yes, Lordship. Yes, Lordship.
So this code is putting in that question.
Yes,
Where is that agreement?
Where is that agreement?
No, that agreement, there is no such
So you
agreement,
want
my
to say
lord.
that there is no such agreement.
No, there's no agreement. All this 16th day of June, Prostina is one of the, my lord, I'll just make myself clear again, my lord. I understand, my lord.
Okay,
this
okay,
is,
let us go
so
by you. See what you say.
Prostina Sangma, my lord, is a wife of Melton and Mara. She is also one of the Nokma, out of the 10 Nokmas, my lord. All the Nokmas
See, once you are under one association, we are
Yes.
not identifying you individually.
Yes, exactly, my lord.
We have one identity before this court.
Yes, my lord. So,
Okay.
so
Now,
yes,
all your members, what they do in their individual capacity,
yes,
it's none of our concern.
exactly, my lord. Huh.
Okay. What your association does, or what the president or the secretary in their official capacity do, that is what our concern is.
Yes.
Now let us just see what is the stipulation made in page 11 of this, which you have enclosed in this your thing.
In the additional affidavit?
No, deed of agreement. Yes, the last one which you have referred just.
Lordship. So
What does it say? What is the clauses say?
So it reads, this agreement is executed for the purpose of authorizing the second party with authority to represent for and on behalf of the first party in matters pertaining to compensation of the land acquired by the government for the purpose of setting up the Balpakram National Park.
It means this one particular one Nakma out of 10 Nakmas, authorizing these two second parties.
Yes.
Those who are president and secretary of the association.
Of the association.
Yes. Now he is if this first party is a member of the association, what is the need of doing this authority then?
Precisely. What is the need? And where is the reference to this amount of money and the checks?
Let us go further, then let us see. Just try to see.
That the first party, who is the Nokma of Nawa Rocheng Aking, hereby agree to authorize the second party to act and do all things necessary for and on behalf of the first party in matters pertaining to compensation of the land acquired by the government for the purpose of setting up the Balpakram National Park. The second party hereby agrees to act and do all things necessary for and on behalf of the first party in matters pertaining to compensation of the land acquired by the government for the purpose of setting up the Balpakram National Park.
So it
That's
means
all
we
it
can say
says.
there is no unanimous decision on the part of the association to come to this. It is only one single authorization your president and secretary was holding.
My lord, I think we are shifting little bit
Exactly,
from
we
the
are
points,
shifting,
my lord.
definitely we are shifting.
But because, my lord, these
But
are
since
all
this court has
technical.
already passed some order
Yes, my lord.
asking for documents and all,
Yes.
it
No,
becomes necessary for this court actually just cannot sideline
yes.
that order.
Exactly,
It may
my
not
lord.
be that much relevant. We
Yes.
do not know how much.
Yes.
If you find something against you also, how much bearing it will have on the power of attorney also, that also.
Yes.
And just before that, kindly have page 7. This is a resolution adopted by the executive committee of this association. Part of that additional affidavit.
Page 7.
Lordship.
See, things are very fishy, like it's making us suspicious.
And just kindly bear in mind, my lords, the original writ petition, which my friend was pleased to read out, that which was disposed by the then Guwahati High Court, that was passed in 2002, in the year 2002.
Yes.
Now, this resolution was adopted on 12th June 2010, much later. So then it reads, date is 12 June 2002. I'll just read out from the top. Resolution adopted in the executive emergency meeting of Balpakram Aking Nokma Social Welfare Association, South Gardens, Meghalaya. Date 12 June 2010, time 12 noon. Venue residence of Derison G. Momin, Nokma of Agimpal, Akingland. At the very outset of the meeting, the president of the association, Shri Arvinstone C.H. Marak, presided over the meeting and welcomed all attended members from the affected Aking Nokmas and close clans, sons, Ochra and daughters. He also explained the Aking Nokmas how the government have acquired their traditional land for the purpose of setting up Balpakram National Park by paying a very less compensation and not even the rate fixed by the GHADC. The president also apprised the members that they have been agitating for their redress of their grievances, and they also have spent quite amount of money, but till date they haven't seen any fruitful result. The president have also stated that the fight for compensation need to be carried out, but since they are illiterate and finds it very difficult for them to consult proper advices and also to run from office, therefore he proposed that he should authorize some literate person among the members as attorney to work for and on behalf of the association. The secretary approved the members present in the emergency meeting that the association have been fighting for past 8 years and also spent large amount of money in this regard. The attended members unanimously resolved the following resolution as under. After detailed deliberation and suggestion from the attended members, it is resolved by the affected Aking Nokmas to engage, entrusted and nominate to appoint Sri Arbistone C.H. Marak, President, and Derrison G. Moment, Secretary of the Association as attorney to specifically deal and handle the case at the High Court pertaining to acquisition of land for the purpose of setting up Balpakram National Park at South Gurals, Meghalaya. In this regard, individual Aking Nokmas has authorized the President and Secretary of the Association to do all necessary and ancillary acts for and on behalf of the members of the Nokma Association, and they are further authorized to appoint any other person as attorney on behalf of the association. The decision of the President and Secretary shall be binding upon all members of the association. As no more agenda to discuss, the meeting wind up with vote of thanks from the chair, and then they have given the...
So that clarifies his stand then.
Yes. Now kindly see one thing. Court has referred to this agreement, which is at page 11 of the writ petition. The issue raised by the court was the recital with regard to the checks.
11 of
and
the writ petition.
Page 11 of the writ petition. That original power of attorney.
Yes.
And the stipulation at clause 5. One of the conditions.
Yes, all right. Yes, we have seen it, yes.
So court's query was with regard to this money. What is this check? How much is the money that was agreed to be paid as a share for the attorney? Where is that? There is no reference anywhere. That document has not been placed before the court.
But then will it be relevant for deciding this petition?
Like I said, this was a concern from the court itself to examine whether there was any kind of exploitation at all, and what was the understanding between the parties. But yeah, I'll leave Lordships with that thought for a moment. I'll come to the next point. Kindly then see, my friend has referred to page 36 of the writ petition.
About that,
the observations made by the collector
yes,
of South Garo Hills. This is dated 17th August 2012. Now thereafter nothing happened. They were aggrieved that this was not sought to be implemented. Aggrieved to this, they kept on writing several representations to different authorities, and then finally they approached this honourable court by way of a writ petition. Lords will find the order at page 63.
yes.
Lordships have it. This is an order dated 11/2/2019. Heard learned counsel for the petitioner, Mr. R. Gurum, who submits that the petitioners have filed a representation dated 22nd May 2017, addressed to the respondent number 4, and prayed that respondent number 4 may be directed to dispose of the representation. Respondent number 3 and 4 are hereby directed to dispose of the representation by speaking order within 3 weeks. Now, this was disposed of by a speaking order which is at page 65.
Yes. What is the date of this order? See the previous page, 64, they did. 4th March it is communicated.
4th March 2019. So
Yes,
kindly
sir.
see
Yes.
page 66, the last paragraph onwards.
Yes.
Considering the whole gamut of the petitions filed by the Balpakram Aking Nokma Social Welfare Organization, I find that the petitioner cannot agitate any more to challenge the quantum of compensation paid to them, as they have executed the agreement with the Forest Department accepting the rate of compensation of 1.5 lakhs rupees per square kilometer, inclusive of all costs prior to payment of compensation, which are matters of record. The remedy available to them under Section 18 of the Land Acquisition Act 1894, which has now been replaced by the new Land Acquisition Right to Fair Compensation and Transparency Act of 2013, which also has a similar provision like Section 18 of the Land Acquisition Act in Section 64, cannot now be relied upon by the petitioner due to time bar. The time limit provided for reference to the Land Acquisition Court in Section 18 of the Land Acquisition Act is maximum 6 months, while 64 of the Land Acquisition Act of 2013 provides for a period of 1 year if the collector is satisfied that there was sufficient cause for not filing it within the period specified. As has already been observed by the Honorable Judge of the Guwahati High Court Shillong bench, it is now too late in the day to challenge the award made some 7 to 15 years before. I do not find any section of law under which the petition of the Balpakram Aking Nokma Social Welfare Association can be entertained in the present circumstances. Having accepted the quantum of compensation in full without protest, they cannot at the same time.
Is it by the same collector?
My lord, it may not be the same collector, but the same office, collector of South Garwal's Bagmara. So this has already been passed. Now, my friend's prayer, my lord, will kindly see. At page 7.
Yes.
In the premises aforesaid, it is therefore prayed, Lordships may be graciously pleased to admit the petition, call for records, issue rule, calling for records, and so on. Why a writ in the nature of mandamus should not be issued, directing the respondents to make payment of compensation, as per the report of the respondent number 4, dated 17/8/2012, to the petitioner's Nokmas by quashing the impugned letter dated 4/3/2019, which I just read. So this should be quashed, and the observations of the DC contained in 17/8/2012 should be given effect to. That is his prayer, my lords. Now this observation was made in 2012. He approached this court in 2019. Pursuant to the orders of this court, the South Garo Hills collector considered their application, considered their representations, and passed a final order on 4/3/2019. They want that to be set aside, and some other representation which is more congenial to them, that should be upheld, and they should
Do you require to go to all those things? You see, like,
I'm just pointing out
ourselves to law, it's just fair. You see,
so what my friend was
it
saying,
is
he has a
not
new
about-
cause of action.
It is not about starting a fresh accusation. It is not about giving, you see, or reopening the accusation which already stood closed.
Correct.
Proceeding which stood closed.
Lordship.
Just if he can show that yes, there is a provision, let us see that. Otherwise, there is no question of entertaining his.
So from what I understand of my friend's submissions is that irrespective of what may have transpired in the judgment of the Honorable Guwahati High Court, a new cause of action has formulated in his favor.
See, there are certain issues. First of all, once an issue stands judicially decided, can that issue again be revived by it?
In my humble submission, no.
That is one issue.
Can't be.
Second thing, his claim is about enhancement of rate. Now, without filing any application under Section 18,
Lordship.
can he maintain that? Section 18, you see, if you see, it stipulates the period of limitation.
Lordship.
It is highest is 6 months. We are not going to the new act. New act is not going to.
It's not relevant at all.
So it is under the old act.
Yes, yes.
So the maximum time is 6 months, as has been reflected in Deputy Commissioner's response to their representation. Now, it is 6 months in a case where he does not have knowledge of issuance of award.
Correct.
Or the preparation of award. For other cases, it is only 6 weeks from the date of his knowledge under Section 12(2), notice under 12(2), or from the date on which he, or on the date or on the day of the preparation of award where he is represented.
Lordship.
Okay. So 6 is 6 months. Now that period has gone long back.
Lordship.
He has not preferred any petition. In such a case, where is the question of entertaining it?
Precisely. He wants to
Now,
go
you see,
outside the
so
act.
far as the enhancement of compensation is concerned, the law prescribes procedure in which manner you should do it.
Lordship.
You bypass that. You do not do it. But take a different route you want.
Correct.
And then you say, please entertain it. Can it be?
That's what.
When law has a procedure laid down, now you sideline it and you say, no, I have filed a representation, you have given consideration to it. Your officer said that yes, the rate paid was much less than these things. Now please, since he has given, it has given us. Can you do it in jurisdiction by overlooking the entire provision of
Precisely.
litigation act?
That's the issue here.
Let him satisfy that part.
Lordship have correctly summarized the position. That there's a self-contained act.
If we go into all other aspects which you have said, it may apparently strike at the roof of the proceedings, locus standi. But then this court right now is not much interested to go into that.
Lordship.
Because you see, even if we can find that there is some ulterior motive or something is to their deprived, but then this power of attorney would remain. So apparently to say at the threshold that he doesn't have a locus standi at this stage may not be proper for the court.
Lordship.
Let him say, but then let him first satisfy that part of the court.
My lord.
Two things against him is first of all the earlier round of order passed in the earlier round of litigation, And the second thing is that while deciding or enhancing the rate, can entire land acquisition be bypassed and the new procedure as adopted by the Deputy Commissioner by himself opening the case be adopted.
Correct.
My lord, in order to reply to answer to the queries, my lord, I would like to take my lord to one of the judgment, 2022 SCC online, my lord. This is a division bench passed by the High Court of Kolkata, my lord.
2022, just give us a citation.
2022 SCC online.
Yes.
Cal 1328. 1328, my lord.
Kerala.
1328, my lord. The paragraphs would be 21, 24, 25, 26 onwards, my lord.
Yes.
Here, my lord,
Kolkata.
Kolkata is a division bench of the Kolkata High Court, my lord. Here also concerns about a delay in claiming of the compensations, my lord. Delay.
Is it similar case?
My lord, may not be exactly similar.
Probably, Mr. Even.
Yes,
you have got the thing. Now, one thing is that the question code is putting is that.
Yes.
Can there be any other way of enhancing the compensation?
Not prescribed as per the procedure of
bypassing the procedure or by overlooking the entire procedure.
My lord.
Can it be? Just give us this.
My lord. My lord, may I take a small date, my lord? I'll come back with a
you
query.
See, you can take this thing, but then that is the only thing is this which you need to.
My lord.
Which I should kindly sit on that thing. This code right now, what comes to this code mind is that once when act prescribes certain thing to be done in this way,
it has to be done in that way.
Done, not in other.
Correct. Yes. Yes.
So that is what the answer is simple.
Yes.
Why to go into all those things?
My lord.
If he cannot show us law, then we'll finish it. You see, like within one line order also.
My lord. My lord.
I'll
try my best to persuade my lord.
It's not the final view of the code.
My lord, I understand. I understand.
Not that. But then you have to show us.
My lord. My
lord. Because once your claim stands barred under the Land Acquisition Act, whether that can be revived by resorting to any other thing.
Any other means. My lord,
Well, that is exactly his entire case, that irrespective of what was decided by the Honorable Guwahati High Court, by virtue of the successive representations, a new cause of action is formulated in his favor. That is his entire case.
You see, he might be successful in influencing some of the officers of the government.
That's exactly what has happened here.
To some extent.
Lordship.
But then we are concerned with law.
My lord. My lord.
You see, even admission of the government would not create a right in his favor until and unless he shows that he has a right.
My lord.
Enforced.
So I'll have to.
But then it will be quite tough on your part.
I know, my lord.
I don't think there will be any such law.
My lord.
Grant of compensation bypassing
my lord.
Provision of land acquisition.
My lord, at times this kind of complicated and this kind of matters sharpens our.
Mr. Even you were giving a try. I would have given up long back if I was on the side.
My lord, the entire basis of their claim is the rates fixed by the GHADC. That is the entire basis.
That cannot
GHADC is no authority.
Yes,
there are several decisions.
It
is the collector.
I bow down. That I bow down.
Yes, not even any other superior officer.
Yes, my lord. That I bow down, my lord.
So I've gone through the representations. Entire claim and entire basis is
but
there.
Then we will not go to the rate. That is for sure. Only thing is that whether court can. But then the thing is that if he is successful in showing, then we have to go to the if you have to discharge the duty of the special judicial officer, then you have to go to the
my lord. Obliged.
When do you want it?
My lord, after the elections, my lord, after the elections, because maybe somewhere first week of May.
It's okay, after 2 weeks on the request. But then issue is quite interesting, though we have got to these things. Though it apparently seems simple, but then you have made it. Nothing more.
Highly blessed.
All right.